Okay, so I think if you haven't guessed who's speaking, where are you? It's quite clear, except for Sam, who is still on the fence, I think.
I'm a lawyer.
Good. But I guess the first question I have for everyone is, it's all very well to speak about precedents in general, but when you're talking about precedents in this sunshine sector, and let's actually take it to the cutting edge, let's not take it, let's not discuss broadcast as an example, because that's been with us for a long time. And there's, even in India, there's precedents that have been developed. Let's actually even not talk about telecom, because we've been with telecom for a long time. Let's talk about IT. Let's talk about more cutting edge issues. And if you have a cutting edge issue, for instance, let's take Facebook, or let's take one of the new social media platforms. And if there's an issue around a social media platform, and you need to get justice, and you go to a court, and you ask, and in that court, you have to convince the judge in some way, but there's no Indian precedent. So you're forced to rely on something that the US court has held. How would you deal with that, Shreyas? And down in the courts, how does it actually work?
So the question that you pose is different from the proposition, but I'll answer the question. There are, in fact, many such situations. Many of us face it in our practice. Every case is unique. And therefore, the case in the TMT sector, in the way that you put it, can be so unique that it really hasn't occurred in India before. And it is also, with the number of blogs that are alive, it's not just, you don't look to, the published precedents alone, but you also look at experiential outpourings that's freely available and friends practicing. And so there's a first level of check that is done informally, speaking in the realistic tone, continuing to, of checking with friends practicing in the area, saying, no names, but seen something like this before, etc. There is also, of course, the volume of data that's available on the internet and the way things have played out in other jurisdictions. But to me, that is narrating a story that has taken place in a different jurisdiction, which is different from relying on a precedent that is an international precedent. So the way in which a court might have approached it in the case might be instructive to glean some of the arguments that might have led, but I don't think it would have mattered one way or the other what the court ultimately held. It is what I would look for as a trial lawyer would be the issues that the courts have identified, which may be useful, as Sam put it, as which hat I'm wearing. I may be arguing the opposite proposition of the one that was held elsewhere. But it would be useful as a pointer to refer to, rather than throw the book at the judge. And
so are you saying that international precedents are useful? Because that sort of sounds like what you're saying now.
No. So I'm definitely saying that to use the precedent as this is the way the court has held and therefore follow the same is not the way it can be used at all, full stop. And to that extent, it's definitely arguing against the proposition to say that it's crucial to refer to these cases as a matter of precedent. It is not possible to do so, is my frank opinion. But I think it is equally foolish not to be aware of what's happening elsewhere. Nobody can, that's not my brief over here, to be ignorant of developments that are happening elsewhere and to be siloed into not seeing what has happened. And there I would say it is equally important to look not only at what the judge's view of the case was, but also how that view is represented by how it is seen by the industry, let's say. How have other interest groups reacted to it? To that extent, precedent is not the view of the judge is not the determinative, definitive view of the issue. And therefore, amongst the sources that I would look at in that new, unique situation would certainly be the judge's view, but would also be the reactions to the issues. And as I said, it is important to identify the issues that are emerging, rather than look at the view of a judge in a jurisdiction. There is more to it than a view of a judge while dealing with sunshine issues. He may have got it wrong.
So, Rajiv, you have operations around the world. And certainly this kind of an approach must be something that keeps you up at night. That a judge in one country is going to hold one way and a judge in another country is going to hold another way. How would you react to this kind of a country by country approach?
Well, I'd like to step a little back to answer that question. Start by looking at whether there is a case made out for plurality in this space. I really don't think so. Okay, and if you see the instances where there is a case for plurality made out, there are socio-political and related reasons which are there, which is totally absent in this space. So I think there is some level of uniformity which has to be there, and what the reason, another reason for that is also that with the emerging technology, we're moving more towards virtualization, and with virtualization, technology solutions become more location agnostic, and that also brings us to a need to have a uniformity there. From a business perspective, I would be looking at some level of certainty, some level of predictability as to the outcomes of a particular issue or a particular dispute. And this is something which would be an expectation even in a jurisdiction where the law may not be that mature or it may not even exist that way. And that I think is a reasonable expectation in this kind of a sector, which is a sunshine sector and where which has nothing to do with the socio-political or the customary practice related things. And I think from that perspective, it's important to secure that uniformity, and there's nothing wrong in expecting that uniformity in the laws. Now, for the people who are arguing against this one, my question would be that how do you make out a case for plurality? Now, it is one argument to say that yes, judges have the flexibility to lay the law, they should not be bound by precedents, which is a valid argument, but then where does it take us? If we have been in a common law framework, we have had value of precedents all along, and I'm only advocating for the same way in which international precedents are currently applied in this country to be applied for the space also. It may be a little more applicable because of the, I won't say lack of laws, the level of maturity of the laws and the space of this country. So this question which you mentioned, we go on the conscious assumption that what we know of from precedents in other countries are going to have some level of impact, some level of effect, okay, some level of persuasive effect also on those which are going to happen, and that's the only way to move forward. I cannot do business, I cannot move forward implementing a solution at a location assuming that the outcome could be anything where the law doesn't exist, and which is the situation in this country now.
So I think then the point is perhaps we can go beyond the argument of whether precedent should apply in the same way as it does today, because I think that will be difficult to argue that it can't.
Yeah.
The judges will apply international precedents the way they have applied international precedents for all other sectors. But in the okay,
I beg to differ. So there's two things now. So now this debate has gotten widened, right? Now we're talking about a new sort of lex mercatoria.
no, I'm actually trying to narrow it down.
But Rajiv has just widened it out, saying that we need to look at a uniform system of law that applies because the sector is
Correct.
is geography agnostic.
Yes.
We're now talking about a new system of law that is geography agnostic as well. And so the nearest, or the closest precedent, or the closest sort of model would be the old lex mercatoria when before we got to national boundaries and systems
Can
of
we
law.
also say that the law on arbitration is
Also
a
very
living example of that?
So, but I will also provide a counterpoint. There's a very active system of, so we're all common law countries, right? But if you've ever done employment litigation, you will find that there is no such thing. There are broad principles of employment that every country above. But if you're litigating employment in the US versus employment in the UK versus employment in India, the concept of employment versus labor law, there is complete plurality of.
So that's Rajiv's point.
No,
there is a socio-economic reason why in labor that is there. It doesn't exist for technology.
And the question, Rahul, is can you divorce any system of law from its socio-economic context? Okay, ultimately, the law provides a framework for you to do a bunch of things, to assign rights to each other, and all doesn't exist in a vacuum. We're all talking about something in a socio-economic context. Now, a big company like HP, and I've been there at Infosys, we like to know that wherever in the world we are, we have the same sort of precedents that we can apply, or the same sort of rules that we can apply, right? But when you talk about Facebook, and let's go back to social media, the way that people consume social media is very different and in each society. In India, we view social media as I don't know what, but I mean, well, I mean, it's good tool. Actually, so social media has provided a tool for the sort of cowards of this world to abuse people. I mean, Maria Sharapova versus Sachin Tendulkar, anybody who has anything that people don't like. But see, look at it, right? So in a country like India, where we have so many different cultures, communities, and things like that, you cannot take an American precedent and apply it to an Indian situation. Asking an Indian court to say, because America treats a social media post in a particular way, means that you have to treat it, just won't work. They will not buy it because they're applying it to a particular socio-economic context. Even within India, a rural-urban sort of a court somewhere in a smaller town may not view the issue the same way, because ultimately we're all human beings and we're influenced by everything that's around us, and I don't think that they will buy it that way.
So we seem to have now two strands developing. One is really the big corporates, which if you're talking about arbitration, you're talking about big commercial transactions, there's probably a uniform social environment within which they operate. And so if you're talking about cloud computing, those kinds of challenges, yeah, that's probably going to be uniform around the world. There's probably a better chance that international conventions, precedents will apply here. But as Sam is saying, you can't say that for Facebook. Even though Facebook is a big international corporation, Facebook standards for what is decent in the US varies dramatically from what Iran thinks is decent, just to take an example without any specific reason. So how then would you apply an international standard in that context?
This is where I would like to start by first laying a theoretical foundation for why we can be geographically agnostic when it comes to developing law for these sectors that we are talking about. And all the arguments that are true for arbitration or for some limited areas are extremely true a fortiori for these areas. So where I want to start from is, on the one hand, is what's happening to reality today. It's an old philosophical debate as to reality, whether reality is the world outside our minds or is it all inside our minds? And then we come to a conclusion that the world is really what is inside and outside. And now we have this cyber world which completely changes that and makes it even more complex. And it is my contention that because of the cyber world being out there, where a lot of human thoughts are getting concretized in a way that they never used to be before, and they can be shared seamlessly, we're actually moving to a convergence in human consciousness. And this is something like the counter-argument which is made to certain human values which we take for granted today. This was the same argument which was made against equality. It was the same argument which was made against giving equal rights to people, which began with the Enlightenment movement in Europe, and it was said there are socio-economic differences. Then you have this idea of Asian values, and then they have this idea that there are different Arab values, and then you realize that no, there can be human values. So in the same way that we met that with the arguments of the Enlightenment, I would say we are at a second cusp of where humanity is moving towards a convergence, and these social differences are becoming less and less important. I'd like to take a very cutting-edge example, as it were, on Facebook itself, or web hosting of photographs. And I just happen to know that this is a case that we've reported where the European Court of Justice had to consider this question as to which state had the jurisdiction in respect to photographs of a German woman which were wrongly put up on a website. Whether German courts would have jurisdiction or whether it would be the courts where the website was domiciled. And it was not possible to find out, and so the courts made a certain ruling based on that, on the fact that the aggrieved person lived in Germany, otherwise she would have no redress at all. Now, I don't see in this example how our socio-economic setting makes a difference, because here the issue is one of privacy, it's a human value. So that is why we come back to, just to finish off on two issues, and then and that is why I want to emphasize, not just that we should look at international precedents as we've been looking at them. No, it is absolutely crucial. So I emphasize the crucial and nothing less than crucial for us to look at such cases so that we can come to a common jurisprudence, a common law in this area.
I have a quick response before Sam, because one of my other practice areas is arbitration. And I can see the stark differences, I'm afraid. Arbitration is uniform, not because of a human value to arbitrate, not because of an enlightened renaissance across the world that arbitration is better than litigation. It's because in the late 1950s, countries actually sat together to negotiate the New York Convention. It is the world's most successful international convention. There is no doubt about it. And having reached that consensus is what it takes in the international legal system. And so once the convention was reached, then there was a mixture of both harmonization as well as enforcement into the municipal law that led to the success of arbitration. It has nothing whatsoever to do with a shared sense of value. In fact, there were debates between both the civil law countries as well as the common law countries, arriving at which is why it's procedural light, and it enables parties to be as flexible as possible. But I do take one other point that you mentioned, which is the problem of private international law. Why is it that these cases are so relevant, seem so interesting? It's perhaps because of the India, for instance, has chosen not to have a private international law statute. Switzerland has it. Now, we now look to our shipping cases in India to determine whether principles of domicile should apply to a commercial entity or not. Now, are you going to apply it to servers? Are you going to apply it to different entities? So there is a lack of availability of legal literature in India, I'm speaking on India, on private international law, which is causing severe problems across industries. And it is, of course, and it's not only IT that is global. If you look around this room, there are products manufactured which would have passed through almost every country in this world. And there's a global supply chain in all products. So I would ask, what is unique about the sunshine sector? It doesn't exist in a world outside the rest of the other sectors. And so the problem is of actually arriving at a creative answer to the private international law problem in India, rather than ad hoc saying this is a sectoral issue that requires international jurisprudence because of IT being global. I think that's the wrong way to approach it.
But I think the point, and I just wanted to keep the focus on I think the new point that came out of there, which seemed to be that today, by all of us, by participating in the internet, have agreed to participate in a common platform that knows no boundaries, that has no national legal restraints, and perforce are bound to subject ourselves to whatever the consequences are of operating in that kind of an environment. So your argument, Shreyas, which is that we have within India, we will have our own ways of dealing with things which are different from the ways in which people deal with it in other worlds, which is probably relevant and appropriate in the employment law example. But if you, out of your own volition, decided to participate in, and that's why we call it the sunshine sector, because in a sense it's the only sector that allows people, while putting their feet within a particular national boundary, can actually make an impact to someone who is sitting in another national boundary with fairly serious consequences. Under those circumstances, don't you think that there should be a stronger move towards a harmonization than not?
Okay. So, and before Mr. Nagendra so I can see
private international law issues.
No, and not only that, I can see him itching from a Facebook sort of perspective as well. But okay, so now I suspect we've gone much further afield than our sort of, are we going to use the reporter for the short answer is yes. Okay. So despite all the, so this is, but in that sort of a circumstance, and social media probably is actually less problematic because it is still about people. There are other laws that give you remedies, libel and to defamation and all that, or intellectual property theft. There are other laws. We're actually going to start moving, and so from a person-to-person interaction perspective, I don't think you're going to get a uniform thing. So somebody who posts something on Facebook that you disagree with, you're probably going to look to your municipal law. The fact remains, however, that there are interesting monetization propositions behind all of this thing, right? So everybody consumes Facebook for free. The stuff that Facebook's doing to actually monetize and pay for all that expensive infrastructure that's sitting behind it is actually far more interesting. I was talking to somebody who operates in Southeast Asia, and they're talking about how new age financial institutions are using information gleaned off your conduct online to profile you for products, financial products, right? So whether you'll be pre-approved for a loan, whether you will not be pre-approved for a loan. And I'm thinking, hang on, how is that possible in countries where there is, strong privacy law? And the answer was, oh yeah, in countries where there's a strong privacy law, we won't use it, but where there's no privacy law, we're going to use it. And so suddenly you got this whole have and have-nots kind of thing. So we're going to go, and then you take away things like Bitcoin, Second Life, places where you have virtual property, and the world gets exceedingly murky. And while I would like to think there was an enlightenment somewhere around the corner, I think we're going to be muddling along for a long time, trying to figure out, because ultimately you're going to have to look to recourse and enforceable recourse. Arbitration provides one such mechanism, the courts provide the other such mechanism. The third mechanism obviously includes baseball bats, broken knee, fractured kneecaps and stuff.
In Bangalore, ADR means unknown dispute resolution.
We're not going there. I'm not going there.
To the non-Kannadigas, it's a reference to the mafia don.
This very position of haves versus have-nots, which you mentioned, doesn't that itself make a compelling case for uniformity?
Okay. I will agree with you that it makes life a lot more simpler in a seamless global world. And yes, it is seamless and global. You can interact at the speed of light, literally as fast as light can travel, to have something that's similar. But our country is going to give it up. Are they going to agree to something like that?
I think the question is not are they going to, but is that the direction we would like to move? Whether they do or don't is a question of will they sit around the table and negotiate a New York Convention?
Tying it back to the reporting.
And so, if we as lawyers could start using international precedents, we'll do our little bit to make the whole world uniform.
So, and Rahul, the answer is I would like to, because that then because if you're expecting, given that the interactions are the same across the world. So if you do an e-commerce transaction, it has the same characteristics pretty much everywhere. If you use an electronic signature, it looks the same, whether you use a biometric signature, whether you use a digital facsimile of your physical signature. I would like to use it that way. Because they have the same characteristics. If I sign something, it's signed, whether I signed it in the US or in India. Unfortunately, we don't have the ability to say yes. Something that's signed using an app in the US is probably valid and binding and enforceable in court as a contract. Whether in India, I know the Delhi High Court has said that since Schedule 2 to the IT Act is not notified, digital signatures are the only valid form of electronic signatures. So I would love to have harmonization. I don't think we're going to get it. And whether you can apply reported case law, that's
just amplify that with a kind of biblical reference. I think putting the burden of uniformity is really asking for too much. Even when you're seeking a reliance on international precedent, I think at best you might have more voices in the Tower of Babel if there aren't enough such discordant voices.
So let's leave that for a moment, because, and I want Rajesh to talk about this for a minute. There are sectors where technology has moved so far ahead of anything else that you actually won't have discordant voices. You won't even have a voice. You will struggle to find one person somewhere in the world who has actually had the opportunity to see this. Under those circumstances, shouldn't we use international legislation? Am I just sort of doing a leading question which you can only answer yes to? But I guess the point I'm trying to make is that there is that other sector, there's that other angle to look at as well. This is the reason why it's a sunshine sector. It's because the sun has just about risen on the sector, and there is no light, and whatever little ray of sunshine we get, we've got to grab.
Exactly.
Can I just add one input before
Sure.
you? Is that why are we seeing international legislation in this area which may bring uniformity and following precedents which may bring uniformity as being at odds? Why is it not entirely complementary? And Rajiv, back to you.
No, I think they are really complementary, and what we're trying to do is, by relying on those precedents, is to fill in those gaps in the interim, right? And that is going to pave the way for legislation making in that space. And it may come out. Now, Sam did mention about some of the specific issues where there are cultural sensitivities. Those are going to be different. I don't expect those are going to be uniform at any point in time, right? So those remaining different, there is still a possibility of drawing broad principles to fill in those gaps which exist here in the law until we have a robust legislation in place. And I believe that this will happen, and this will actually pave the way for a uniform principle in those legislations, even though the micro level requirements, the level of stringency with which it is implemented and all could differ, but at a principle level, these are going to be the same, because this whole fabric of this thing, wherever it is the same. So that's my thought.
And Shreyas, I just wanted to actually also touch on, when you take these international court decisions to the High Court or the District Court, how are they received? Practically speaking, how do the judges receive it?
I think we
Do they
don't-
accept it? I don't know, because I don't go to court. See, I'm one of those
you
guys
don't,
who have
but I
no
think
eyes.
you're-
So
you're-
for my personal edification, if you could,
amongst
you
less
know, everyone
than
else
10
knows.
people in this room.
Yeah,
so I feel
exactly. So we
you
should
know,
ask the,
Well,
Yeah,
throw it up to the
so-
audience as
yes.
well. What
Yeah,
is it
I'm
useful
sure.
at all?
would you cite case law? How do you cite international precedents in this space?
Can't? Not at all?
Maybe High Court or a Supreme Court level may think about it, but I think lower courts ignore it as a.
If there's no precedent whatsoever,
Even then, I don't think they apply the final judgment.
but then how will they come to a conclusion if they don't understand, say, the various issues that are involved, or will they just rely on their own logic to find a solution?
I think what they do is they apply the logic from an Indian law perspective, that, like as they, on a Facebook issue, they will look at the privacy law as applicable in India from a constitutional law perspective, right to privacy, all those things, but not, I hardly see at a district court level or at a lower court, next to impossible, but at a higher level, yes. I just want to add a flavor to the discussion so far that I had. I had experience of working for more than a decade for Telecom and media as an in-house counsel. One issue that I want to highlight is when the consultation process happens in both the TRAI, which is the regulator for both the sectors, and TDCI, which is the tribunal, the consultation process for framing of the regulation, the delegated legislation, uses international laws and characteristic on the life cycle of the industry. Like in telecom, they look when the pricing happens, what stage. So since they have used, at the framing of law itself, they've used that process, I believe it's important that when a dispute occurs on that point, it is very important to bring the international precedent on the facts before the, especially a tribunal is specialized, to say in what context would have that law been made at that time for various industry. And definitely, I will say it's crucial, but not the determining factor on how to decide it. You need to bring it to the perspective. And to add that, it's also important, as Mr. Prasanna said, it all depends on the judge at the end of the day, because I've seen more than 5 chairpersons of the TDSAT in the last over a decade, each had a different perspective on the same subject. So I think end of the day, it comes to that.
I want to add one more thing, which is that while you're borrowing from areas which are not strictly binding, right? I think if you look historically, even tort law was a reaction to the Industrial Revolution. So you had principles of agrarian law being transformed into tort. If you look at bots and the law over whether the invasive technological devices on your websites, again, you had to go to the law of cattle trespass that was moving from one place to another. And so while we are here getting excited about using what international precedent is, we cannot again forget the creative options we have even within India. Even looking at our own other systems of law, for instance, which are not directly applicable to the IT sector. But if there are principles that can be gleaned and can be applied, why not? it can be, and I would encourage that kind of creativity and not restrict it to kind of seeing what another case has done whether within
No,
India.
so
or
there's one.
So I'm going to argue in favor of him in
You
that
must.
case. So because I mean, yeah, okay, and this is where I sort of do this whole, but Shreyas, the point is, yes, there are creative solutions. You will look to your local law. You will look to principles of contract. If you're doing an electronically formed contract, you look to contract law and see whether there is or whether it meets all the characteristics. And to that extent, elucidation of issues, application of common law principles from other spheres of law into a sort of digital world, and sort of we're talking only IT here. We're not talking about regulated sectors like media or telecoms, right? In that sense, the way they've taken the law and applied it is instructive to our courts, because that then provides a framework for our courts to look at our own jurisprudence in that space and say, hey, I'm going to take, these are the tools I'm going to take and apply it, and because XYZ has provided me that pathway.
Just to take on, may I just add on to at this very point as to what extent do we look at the precedent, and why is it crucial to look at it to the full extent? And here I take issue with what Shreyas said. He said that we may look at precedents just to see what the arguments were so as to give us more thoughts. But I would say the decision itself is crucial, because the decision, a well-reasoned decision, which lays down principles, is always a fine balancing exercise. There is no issue where there will not be competing claims and interests. And it is the balancing exercise then done by the judges, which have faced similar situations, which I think is of the greatest value, and that is why it is in learning from that balancing exercise that we will gain the most. Over to you, sir.
I was lucky to practice in Bangalore. Way back in 1978 or so, Justice Govind Bhatt, Chief Justice, made the ILR to report American Ethicon, right? American Ethicon case, American Cyanamide case, which ruled the roost with regard to granting of injunction under Order 39, Rule 1 and 2. If that can be applied in a situation like that, way back in 1978, I don't see any reason why a foreign or other jurisdiction precedent cannot be applied today. Today the situation is completely different. We are looking at a complete globalized world, number one. Number two, there are three issues which we have not really given thought to. One is that there is a criminal aspect of it.
The decision not to go there was conscious, because that would then open up.
No. I'll just tell you. There is a criminal aspect of every transaction in the cyber world, which has to be dealt with by the local laws, where it may or may not be appropriate for us to use the foreign law precedent. There is a contract area where common law precedent or even other precedents would be appropriate to be used. The third thing is the regulated sector, where there are regulations already in place, and based on that cases come up, and where we have to use foreign precedents to arrive at a decision which is appropriate in the context of Indian law. Therefore, according to me, since it's a sunshine sector and there is no much material available in the form of judicial precedents, it is appropriate for us to use all the foreign precedents to arrive at what is appropriate for Indian context and Indian with reference to Indian laws. And that is why I feel that it is crucial that we need to use these precedents, at least until such time we have enough material within India. Thank you.
So on that point, and I think we probably should be winding up fairly soon, but I wanted to just end with two slightly different perspectives, just taking off from that point, to talk about one sector where I'm going to ask you and ask the panel how we're going to apply it, and that is privacy. You know today that the problem with privacy is not that India does not have a privacy law. We don't have a privacy law, but we've got enough decisions, etc., etc. The problem with privacy is that the US has one view and Europe has another view. And in this context, which is the international precedent that we must apply? And how do we then create a situation where an Indian court can appropriately decide, even if there is no precedent, which will not exist today in the context of the ECJ's judgment on the right to be forgotten. So, Rajiv, as an international company, privacy is probably a problem that is top of mind, particularly after right to be forgotten. Everyone must be wondering about how we're going to deal with it. But the point is that today it is US versus Europe. And India is sitting there, we have to be part of this global committee of nations because we're doing, outsourcing for both Europe as well as the US. We need to figure out which side of the bread the butter is put on, or is it on both sides, and how do we deal with it? But the point I'm trying to make is, it's easy when there is a consensus of international view.